First of all, I'd like to thank the organizers, especially Prof. for inviting me. But actually, it was not me first. He asked if someone can provide a good overview of how protected areas are being managed effectively in the Philippines. So I asked someone else if she is available, but unfortunately she said that she cannot. So since this limited time to look, I volunteered, but I said that it will not be coming from the Biodiversity Management Bureau of the Department of Environment and Natural Resources of the Philippines, but it will be from a faculty from the Department of Social Forestry. So I'm from the Department of Social Forestry of the College of Forestry and Natural Resources of UP Los Baños. So as our MC mentioned, I have a different perspective on the issue. But before that, I also was involved in policy advocacy because I worked in Congress, but working with advocates of indigenous people's rights and the different laws that are affecting indigenous peoples in the Philippines. So this is where I will be coming from, especially that we know, as mentioned in some of the previous presentations, there's emphasis in the involvement of indigenous peoples in the achievement of the Kunming-Montreal Global Biodiversity Framework targets. So I'm also the Deputy Coordinator of the IUFRO on indigenous peoples and forest landscape. So generally, this is how I'm going to present. And I'm more of arguing about the ineffectiveness of the current system of the Philippines. But before that, may I know who has been to any protected area in your neighbor? Philippines is just below Taiwan, so and Sensei, he has been to Peña Blanca, and we've been discussing about it. But anyone else? It seems to be more of Filipinos coming to Taiwan, right? To visit protected areas. But we know that we also have lots of ecotourism destinations, and of course we have more areas. This is the Tubataha Reef, and that other photo is my university. The background is just like NTU, you have experimental forest. That's the Makiling forest. It's the experimental forest of the University of the Philippines, Los Baños, and it accommodates the ASEAN Center for Biodiversity, aside from other research organizations like the International Rice Research Institute. So I'll present the legal framework, the new expanded National Integrated Protected Area System in 2018. But since I'm coming from the perspective of indigenous peoples, I'm also looking at the background, the historical background of this law, and trying to explain why it's still not enough, or there's some problem with how its targets can be achieved. So I'll show you the status of protected areas in the Philippines and the conflict in policy. So we have this kind of legal pluralism that's keeping us or preventing us from moving forward, just like most of you. And the initiatives coming from the indigenous peoples group in the Philippines, because they are engaging directly with the Biodiversity Management Bureau, that is the state agency in charge of supervising protected areas. Okay, so back to long history. Your neighbor has been under the Spanish colonial government for 333 years, but it's only in 1863 that the Spanish created this forestry agency. It's called the Inspection General de Montes. It's patterned after the German scientific forestry at the time, but it's still early by then, and it introduced this concept of central government trying to allocate forest reserves. So we know that it was taken over by the Americans in the 1900s, and it copy-pasted its policies from the US to the Philippines. Immediately, it established the Bureau of Forestry that did the same, establish forest reserves that later on are reserves not for conservation but extraction. In 1932, we have the National Parks Act that was still under the American colonial period. But that has been the basis for the succeeding areas that are called parks in the Philippines. 1946, we have the Philippine Republic, but we copied again these colonial policies. I'm emphasizing colonial because that's where the struggle will emerge later. And throughout 1946, throughout the dictatorship of Marcos Sr., there has been proclamation for national parks, but it's area based. So generally in 1975, we had this forestry code that classified generally based on the slope. So the flatlands, 18% slope, these are for agriculture, and 18% and above, these are for forest land. And within this 18% and slope, we have the protection forest and most of the proclaimed national parks at the time. This also includes the classification of the marine areas, which are also under public classification, public land classification, public or municipal waters. But that's where the struggle for indigenous people had been, especially during the time of Marcos. We had the worst forest cover and deforestation. So when he was toppled, we had a new constitution in 1987 and reversed this recognition of, or non-recognition of rights. So basically all the laws that are being enacted now are based on the progressive assumptions or rights recognition within the 1987 Constitution, including the recognition of indigenous people's rights to own their ancestral domain and ancestral land. The thing is, of course, it's controversial because it's like challenging the power of the state. So it was later in 1997 that it's not here, that a law that actually implement that recognition was enacted. But before 1997, we had other laws that were enacted. First is the decentralization of governance, so including the management of resources in 1991. That's the Local Government Code of the Philippines. The next year, there is this National Integrated Protected Area System, or the NIPAS law, that established this protected area system. Basically, it made all the previous national parks as like temporary initial component for the state or for local governments to delineate, because many of these proclaimed areas have areas that are already being claimed for private uses. But in 2018, this 1992 NIPAS law was expanded, so it legislated around 94 protected areas with different sizes. But this is the highest level in terms of permanency among these three classifications: initial component, proclaimed, and legislated. So for now, as of this time, because there's a live database of the Bureau of Biodiversity Management Bureau. So based on the classification, we have around 7.8 million hectares of protected areas, but these are classified according to the first is legal status, and then in terms of terrestrial or marine. And these are the locations. So there are more protected areas that are still to be delineated. Those are the ones considered as the initial component. So I just saw the screen and it's large enough, so I copy-pasted the list for you to appreciate the differences in the areas of these listed protected areas, because we are targeting like 30%, but it says that for now our list is 15%. So I was thinking, instead of looking at expanding, we are actually have a lot of work to do in leveling up the initial component to the legislated. So if you can see, most of these areas are initial component in the middle. And you can see this is arranged according to the lowest in area. So you can see that there's a 5 hectare protected area, and the largest is 1 million hectares. That's the whole island of Palawan. This is also considered an initial component. So you can already imagine that this would also have different treatments. The larger would require a lot of resources, but smaller would have special classification. Although in the law, it treats this to be the same, to have a similar structure. So I mentioned in 1991, there is this a local government code of the Philippines, 1992, 1995. It's important, Mining Act, because the problem is we have a lot of areas declared as protected areas, but it's the same agency that classified this as protected areas are giving the same exploration permit for mining. So we know that the secretary of the cabinet secretaries are political appointees. There's no permanency in how they implement these long-term protected area management plans. And since it's very vulnerable to political bargaining, I mean, these mining interests are looking at expanding their operations in the same protected areas. Usually, these other interests other than conservation wins. So that has been the history of policy in the Philippines, and that has been the reason why many indigenous peoples are still suspicious of these policies. And this is the history of legal recognition of indigenous people's rights in the Philippines. I think literature would say that compared to other neighbors, Philippines has a unique law that actually recognizes full rights of indigenous peoples by giving them certificate of ancestral domain title or certificate of ancestral land title that is considered a private property. So just like all the countries that were presented, we also have the Philippine Biodiversity Strategic Action Plan. And just like all the strategies, we're just copying the IUCN recommendations and the usual good terms, like there's a symposium last May 21 to 22 about the 7th report of the Philippines to the CBD. And they have these terms of whole nation approach, whole government approach in trying to meet the targets that are here. But again, my focus is in these institutional challenges, so I'll focus on that. As we can see later in the outputs, instead of 30%, they just put 24% in the targets, maybe aware that it's really difficult to target the 30% as set in the Global Biodiversity Framework. And this is the reason why I'm emphasizing this, because if you look at the document, there's a emphasis in the recognition of indigenous and traditional territories as part of the OECMs. So I didn't include this, but the areas for possible expansion are OECMs in the Philippines, but that's assuming that this include the indigenous people's territories, or what they call the ICCAs. So it's difficult for now because if you look at the administrative bureaucracy of the parks management, this is the Biodiversity Management Bureau, just like Vietnam. That's the central office in charge. But at the local level, it passes the responsibility to a protected area management board. But you can see that the head of the Bureau of Management Bureau is of the same level with the head of the Mines and Geosciences Bureau. Sorry for the blurred. And this causes conflict within one department. It's a secretary, a cabinet secretary that is approving the mining, but also trying to conserve protected areas. So the Biodiversity Management Bureau at the central level, it passes the responsibility of management to a protected area management board. Every protected area has this office headed by a park protected area superintendent, which is the only assured permanent position in that structure. So the PASU works directly under and serves the Secretariat of the Protected Area Management Board. So looking at the areas of the protected areas, there are many areas that has a PAMB, which is later we'll see that it's composed of multi-sectoral representative, but they don't have money even to have a meeting. So this is the composition of a protected area management board. It's very representative, but generally depends on the area and the political boundaries that are included. If it's large enough to include regions or provinces or municipalities, all the chief executive of those local governments are included. So the problem with this is when it's about areas occupied by indigenous peoples, they are just representing 1 or 3 positions in the PAMB, and yet by law they own the area. So they don't agree generally to be just part of the representative in the PAMB. And the problem is most of the remaining forests in the Philippines are within ancestral domain claims. So around 6.9 million are already given CADT, and a lot of it, like almost 6 million, are being applied for. And this is not just terrestrial, but also marine areas. As we can see later, there are certificate of ancestral domain title issued to marine areas, so indigenous peoples can own even the marine areas. So this document is just like following the Philippine Biodiversity Strategic Action Plan, but from the perspective of indigenous peoples. It's just saying that the strategy should be based on recognition of indigenous peoples' rights before focusing on conservation. So these are the same drivers. That is in Palawan, which is a protected area, but it's open for mining. This is my hometown, which is part of the Mount Pulag National Park, but it's converted into agriculture. So these are the general strategy. It's very similar. And this is a sample of a CADT issued, including a municipal waters. This is in the north of Palawan for the Tagbanwa. And this is me getting involved in the promotion of the ICCA bill, or Indigenous Communities Conserved Areas and Territories, which until now is not yet being enacted for the same reason that there are other interests who don't want to give the power to indigenous peoples, because that means that they cannot apply for mining permits. Thank you very much.